F of the statute, the appeals chamber finds that this provision was inserted to alleviate the concerns raised by some states that forced pregnancy provision might be interpreted as interfering with the state's approach to abortion. The appeals chamber concurs with the trial chamber that Article 7 to F of the statute does not impose a new element to the crime of forced pregnancy. Therefore, the appeals chamber concludes that the trial chamber was not required to consider Ugandan law on abortion in its assessment of this crime. Moreover, after a careful review of the evidence underlying the trial chamber's factual findings, the appeals chamber finds that the defense has not shown any error in the trial chamber's factual findings on forced pregnancy. In addition, under grounds of appeal 87, 89, and 66 in part, the defense challenges the trial chamber's findings that Mr. Ongwen was one of the commanders who developed and implemented the LRA policy on abduction and abuse of civilian women and girls. After a careful review of the trial chamber's findings and the evidence relied upon, the appeals chamber finds that the trial chamber was reasonable in finding that Mr. Ongwen was among the persons who helped define and through their actions over a protracted period sustain the system of abduction and victimization of civilian women and girls in the LRA, and that his role within the CINIA was crucial and indispensable. The appeals chamber, therefore, rejects the defense's argument under grounds of appeal 87, 89, and 66 in part. Alleged errors regarding grounds for excluding criminal responsibility. At trial, the defense alleged two grounds for excluding Mr. Ongwen's criminal responsibility, namely, that he suffered from a mental disease or disorder during the period relevant to the charges and that he committed the crimes under duress. The trial chamber rejected the ground for excluding criminal responsibility by way of mental disease due to the lack of evidence which would corroborate a historical diagnosis and based on the expert opinion of mental health professionals who did not identify any mental disease or defect in Mr. Ongwen during the period of the charges. Likewise, the trial chamber rejected the ground for excluding criminal responsibility by way of duress on the basis that there was no evidence at all to hold that Mr. Ongwen was subjected to a threat or imminent death or imminent or continuing serious bodily harm to himself or another person at the time of his conduct underlying the charged crimes. Consequently, the trial chamber found that Mr. Ongwen's guilt had been established beyond any reasonable doubt. On appeal, the defense challenges these findings of the trial chamber, which the appeal will address in turn. With respect to the ground of excluding criminal responsibility by way of mental disease or defect, the defense raises four main arguments under several grounds of appeal. First, it argues that the trial chamber erred in its assessment of the reliability of the evidence of mental health experts called by the defense. Second, the defense argues that the trial chamber erred in failing to rely on the evidence of the court-appointed expert, Professor de Jong, for its assessments. Third, the defense contends that the trial chamber erred by disregarding cultural factors when assessing Mr. Ongwen's mental health. Fourth, the defense argues that the trial chamber erred in its assessment of the evidence of Dr. Abo, a prosecution mental health expert. As to the first argument, the defense essentially takes issue with the trial chamber's findings concerning the methodology employed by the defense's mental health expert, who found that at the time material to the charges, Mr. Ongwen suffered from numerous mental disorders, such as severe depressive illness, post-traumatic stress disorder, and dissociative disorder. For the reasons fully explained in the judgment, the appeals chamber finds that the trial chamber did not err in concluding that it could not rely on the defense expert's evidence, given concerns it had over the defense expert's failure, inter alia, 1, to apply scientifically valid methods, 2, to take into account other sources of international information about Mr. Ongwen which were readily available to them, and 3, to properly test for malingering in Mr. Ongwen. Moreover, the appeals chamber finds no error in the trial chamber's assessment of contradictions in the evidence of the defense experts, in particular contradictions between the various statements and observations made, or between such statements and observations and the conclusions finally drawn. Therefore, the appeals chamber confirms the trial chamber's findings concerning the methodology and the consequent unreliability of the evidence of the defense's mental health experts. As to the second argument, the defense argues that the trial chamber erred in concluding that the observations of the court-appointed expert Professor de Jong had no relevance for its assessment as to whether Mr. Ongwen suffered from mental disease at the relevant time. In particular, the defense contends that Professor de Jong's observations concerning Mr. Ongwen's clinical history, dating back to his childhood, and his cultural context were significant. As explained in more detail in the judgment, the appeals chamber is not persuaded by this argument given the distinct purpose for which Professor de Jong's observations were requested, and the abundance of other evidence in the record concerning Mr. Ongwen's clinical and social history, dating back to his childhood and his cultural context, which were discussed at length by other experts, including the defense's own mental health experts. The appeals chamber thus rejects this argument and confirms that the trial chamber's decision not to rely on Professor de Jong's evidence for its assessment of whether Mr. Ongwen suffered from mental disease at the time relevant to the charged crimes. As to the third argument, the defense contends, inter alia, that the trial chamber disregarded cultural factors when assessing Mr. Ongwen's mental health. In particular, the defense argues that the evidence of Professor Musisi on the trauma suffered by the victimized population of northern Uganda and the resultant mental health problems documented amongst LRA traumatized individuals should not have been ignored by the trial chamber. Contrary to the defense's argument, the appeals chamber finds, for the reasons more fully elaborated on in the judgment, that it was reasonable for the trial chamber not to rely on the evidence of Professor Musisi, since he did not provide specific information in relation to whether Mr. Ongwen suffered from a mental disease during the charged period. As for the fourth argument, the defense argues in particular that Dr. Abo potentially exculpatory evidence relating to the adverse environment of the LRA and its impact on Mr. Ongwen's moral development and childlike personality, even as an adult, was disregarded by the trial chamber and resulted in the trial chambers unreasonably ascribing criminal responsibility to Mr. Ongwen as an adult. The appeals chamber is not persuaded by these arguments. First, the appeals chamber notes that Dr. Abo's evidence about the adverse environment within the LRA and its negative impact on the development of a child was not in dispute during the trial. Second, while Dr. Abo's holistic assessment of the evidence concerning Mr. Ongwen's childhood development included the impact of his abduction and his lack of control as an adolescent over the adverse environment within the LRA, she nevertheless acknowledged that these factors did not absolve Mr. Ongwen of criminal responsibility as an adult for the crimes charged. Indeed, the appeals chamber notes that her characterization of these factors as an important mitigating factors may be viewed as significant for the purposes of sentencing, but not for the trial chamber's determination as to whether Mr. Ongwen suffered from a mental disease at the time relevant to the charges. The appeals chamber considers that Dr. Abo's evidence concerning Mr. Ongwen's lack of control over the LRA environment as an adolescent was not exculpatory of his criminal responsibility for the crimes he was found to have committed as an adult. The appeals chamber concludes that the defense has not demonstrated any error that could warrant the appeal chamber's intervention in relation to the trial chamber's findings on mental disease as a ground for excluding criminal responsibility pursuant to Article 31(1)(a) of the statute. Accordingly, the appeals chamber finds no merit in the arguments raised and rejects grounds of appeal 19, 27, 29, 34, and 36 to 43. With respect to the ground for excluding criminal responsibility by way of duress, the defense challenges under several grounds of appeal a number of trial chambers' findings underpinning its conclusion that Mr. Ongwen was not subject to a threat of imminent death or continuing or imminent serious bodily harm at the time of his conduct underlying the charged crimes, and that therefore duress as a ground of excluding criminal responsibility pursuant Article 31(1)(d) of the statute was not applicable to him. In relation to the defense's challenge to the trial chamber's interpretation of duress, ground 44, the appeals chamber finds that the trial chamber properly interpreted Article 21(1)(d) of the statute, when it held that terms imminent and continuing refer to the nature of the threatened harm, and that the threatened harm in question is either to be killed immediately or to suffer serious bodily harm immediately or in an ongoing manner. The Appeals Chamber further considers that the timing of the materialization of the threat is one of the criteria to take into account when assessing the existence of a threat. Regardless of whether the threatened harm occurs immediately or a later point in time, for a person to be compelled to commit a crime under the jurisdiction of the court, the threat must be present and real at the time of the charged conduct. The Appeals Chamber also considers that the existence of a threat must be objectively assessed. Any prior experiences of an accused person that may have an impact on him or on her at the time relevant to the charges which do not satisfy the threshold required for excluding criminal responsibility of the accused under Article 31(1)(d) of the statute may nonetheless be relevant for the purposes of sentencing in the event of a conviction. The defense further challenges a number of factual findings which the trial chamber relied on to conclude that the defense of duress was not applicable to Mr. Ongwen. These include the findings, 1, of Mr. Ongwen's status in the LRA hierarchy and the applicability of the LRA disciplinary regime to him, mainly raised under grounds of appeal 46 and 48. 2, of Mr. Ongwen's abduction, indoctrination, and life and service in the LRA, grounds of appeal 26, 28, and 47. And 3, on the possibility of escaping from or otherwise leaving the LRA, grounds of appeal 52 to 54. And 4, on Joseph Kony's alleged spiritual powers, ground of appeal 55. As an example, among the several challenges raised under grounds of appeal 26, 28, and 47, the defense alleges that the trial chamber correctly considered the impact of the evidence on Mr. Ongwen's abduction, indoctrination, and life and service within the LRA from his childhood onwards, and the enduring impact of these experiences on his mental health and his free will as an adult. It would have reached a different conclusion, namely that the defenses pursuant Articles 31(1)(a) and (d) were applicable in the present case. In particular, the defense takes issue with the trial chamber's finding that in its assessment, the chamber focused on the situation of Mr. Ongwen as battalion and brigade commander during the period of the charges, and that Mr. Ongwen's childhood experience in LRA was not central to the issue. The Appeals Chamber first notes that the confirmed charges against Mr. Ongwen concerned the allegedly committed as an adult between 1st July 2002 and the 21st December 2005. Therefore, any findings about Mr. Ongwen's experiences prior to this period cannot in itself be determinative of the central issues of the case. In this context, the appeals chamber finds that it was not unreasonable for the trial chamber to consider that Mr. Ongwen's childhood experience in the LRA was not central to the issue. In any event, appeals chamber notes that the trial chamber did take into account evidence on Mr. Ongwen's early childhood. It considered, in particular, evidence about Mr. Ongwen's age and abduction and his childhood experiences in its holistic assessment of the evidence relevant to the ground for excluding criminal responsibility by way of mental disease or defect. Furthermore, at the end of its analysis on the applicability of Article 31(1)(d) of the statute, the trial chamber explicitly noted the defense's submissions emphasizing that Mr. Ongwen was himself a victim of crimes on account of his abduction at a young age by the LRA. The trial chamber recalled that it had duly considered the facts underlying these submissions and also noted the potential relevance of these facts to both grounds excluding criminal responsibility. While acknowledging that Mr. Ongwen has been abducted at a young age by the LRA, the trial chamber noted that the accused committed the relevant crimes when he was an adult, and importantly, that in any case, the fact of having been or being a victim of crimes does not constitute in and of itself a justification of any sort for the commission for similar or other crimes. In light of these considerations, the appeal chamber finds that the trial chamber did not disregard the evidence referred to by the defense, nor did it err in its determination to focus on the situation of Mr. Ongwen as battalion and brigade commander during the period of the charges, finding that his childhood experiences in the LRA was not central to the issue. Accordingly, the defense's arguments are rejected. As a further example, under ground of Appeal 55, the defense challenges the trial chamber's finding about Joseph Kony's purported spiritual powers and its effects on Mr. Ongwen. In particular, it submits that the trial chamber disregarded or failed to give due regard to relevant evidence, and that it erred in concluding that LRA spirituality is not a factor contributing to a threat pursuant to Article 31(1)(d) of the statute. The defense refers to the testimony of certain witnesses that was allegedly disregarded. The appeals chamber, as set out in more detail in the judgment, notes that the trial chamber in fact assessed evidence from a number of former LRA members who testified about the effect of LRA spiritualism on them, and found that while there was evidence that some persons did believe in the spiritual powers of Joseph Kony, the evidence consistently showed that for many persons who stayed in the LRA longer, their belief followed a pattern. It was stronger in the young and the new abductees, and then disappeared in those who stayed in the LRA longer. The trial chamber also noted that the LRA members with some experience in the organization did not generally believe that Joseph Kony possessed spiritual powers, and that there was no evidence indicating indicating that the belief in Joseph Kony's purported spiritual powers played a role for Mr. Ongwen. In fact, it noted the evidence of Mr. Ongwen's defying Joseph Kony speaks clearly against any such influence. The trial chamber ultimately concluded that the issue of LRA spirituality was not a factor contributing to a threat relevant under Article 31(1)(d) of the statute. The appeals chamber finds, as explained in the judgment, that the defense fails to show that the trial chamber disregarded relevant evidence, nor does it show any error in the trial chamber's approach and conclusions. Its arguments are therefore rejected. Furthermore, for the reasons set out in the judgment, the appeals chamber rejects all the remaining arguments raised and accordingly rejects grounds 26, 28 in part, 44, 46 to 26 to 56, 58 and 60 to 63 of the appeal. The appeals chamber concludes that the defense has not demonstrated any error in relation to the trial chamber's finding on duress as a ground of excluding criminal responsibility pursuant Article 31(1)(d) of the statute. Alleged errors regarding cumulative convictions. Finally, the defense challenges the trial chamber's findings regarding cumulative convictions under grounds of appeal 20, 21, and 22. First, the defense argues that the trial chamber erred in rejecting its contention on the relevance of Article 20 of the statute in its assessment of cumulative convictions. The appeals chamber finds that the trial chamber correctly determined that the ne bis in idem principle, as formulated in Article 21 of the statute, serves to prevent a retrial of a person who has been convicted or acquitted on the basis of the same conduct before this court. It follows that contrary to the defense's contention, this provision is not concerned with the question of whether a trial chamber can impose cumulative convictions on a person for the same underlying conduct in the same trial. With respect to the test applicable to cumulative convictions, the defense contends that the trial chamber correctly adopted a conduct-based approach, but misapplied it in relation to some specific crimes, such as the crime against humanity of forced marriage as a form of other inhuman acts. By reference to the language in the Bemba et al. Appeal judgment, the defense identifies the principle of speciality, consumptions, and subsidiarity as forming the core analysis of concurrences in civil law system. The appeals chamber considers that the test for cumulative convictions finds its rationale in the need to reflect the full culpability of an accused person, given that each provision, which has a materially distinct elements, protects different legal interests. What the legal interests protected by each crime are can only be discerned by reference to the elements of the specific crime. If these elements require proof of a fact not required by the other, cumulative convictions are permissible. Any remaining concerns arising from overlapping facts can be addressed in the determination of the sentence. The appeals chamber considers that this approach strikes a careful balance between the need to reflect the full culpability of an accused person while safeguarding his or her rights and ensuring that the person is not being unlawfully punished. The appeals chamber also rejects the defense's allegation that war crimes and crimes against humanity based on the same underlying conduct are impermissible concurrences. As the trial chamber correctly stated, in the conviction decision, crimes against humanity and war crimes reflect, partly, different forms of criminality, in that they complement, in terms of protected interests, the incrimination of the individual specific crimes, which in turn are therefore distinct depending on the relevant contextual elements. For instance, in relation to murder, both as a crime against humanity and as a war crime, while some of the legal interests protected may coincide, e.g., the right to life, the protected interests discerned from the contextual elements do reflect different forms of criminality, and consequently, distinct crimes. As explained in the determination of Ground of Appeal 20, the legal interests protected by a given criminal provision can only be discerned by reference to the elements of the crimes. Furthermore, the appeals chamber rejects the defense's claim that cumulative convictions for the crimes of rape and sexual slavery and for the crimes of forced marriage as a form of other inhuman acts and sexual slavery are not permissible. As explained in the judgment, these crimes have materially distinct elements resulting from the fact that they protect different interests. The appeals chamber considers that while the protected interests may overlap to a certain degree, the fundamental nature of the crime of sexual slavery is reducing a person to a servile status and depriving him or her of his or her liberty and sexual autonomy. While for the crime of rape, it is the invasion of sexual nature of a person's body and the attack on his or her sexual autonomy. In addition, the interest protected by forced marriage as a form of other inhuman acts is not necessarily violence against physical integrity and deprivation of liberty, but crucially, a person's right to freely choose one's spouse and consensually establish a family. Conclusion. In concluding the summary of this judgment, and given that the relevant findings of the trial chamber have been confirmed, the appeals chamber wishes to recognize the extreme suffering experienced by the victims of the crimes committed by Mr. Ongwen during the time relevant to the charges. I will repeat this in French. En concluant la lecture du résumé de l'arrêt rendu ce jour, et étant donné que les conclusions pertinentes de la Chambre de première instance ont été confirmées, la Chambre d'appel tient à reconnaître les souffrances extrêmes qu'ont endurées les victimes des crimes commis par Dominic Ongwen durant la période visée par les charges. Appropriate relief. For the reasons set out in detail in the judgment, the appeals chamber rejects all the defense's grounds of appeal and confirms unanimously the conviction decision. This concludes the delivery of its judgment with respect to the appeal against the conviction decision. We shall now adjourn until 14:30 for the delivery of the judgment on the appeal against the sentencing decision.
All right, we will be.
Dana from the marketing department. All I recall for Christmas are just amazing and beautiful memories, and I really can't wait this season to celebrate Christmas with my family. I love you all. A Merry, Merry Christmas.